give effective and expeditious service, because also for the hearing of cases, I hear the cases within the shortest time possible and deliver judgments and rulings without delay. And that's so Bomet Law Court, where I first headed, being recognized in the first cycle of performance evaluation. We were not working thinking that there'll be evaluation. We were just doing our usual work. And when the evaluation was done, we were found to have reduced case backlog, and we were recognized. That was in 2017. And I have continued to perform my work that way. I've also ensured that the staff that I work with in the stations that I have headed, that is Bomet and Ngong, also embrace that working method, and therefore it has impacted on service delivery to Mwananchi, and therefore it has improved. It has assisted to improve our services to the Mwananchi. I also possess skills with the experience that I have 15 years in the judiciary. I have acquired skills that have assisted me to improve on my judgment writing skills, analytical skills, research skills, which are crucial in my work as a judge of the High Court, considering that the judge of the High Court will be required to develop jurisprudence in that court, and also jurisprudence which is in line with the Constitution. And therefore, I'll be able to do that, considering the skills that I've already acquired. I possess organizational skills. I'm able to manage a lot within a short time just because of being organized, because even my current station, as head of station, there's a lot of administrative work. But with that, I've managed to handle it together with my judicial function, and I've been able to perform in both areas without much difficulty. So I know that I'll be able to perform well as a judge of the High Court and make a positive impact. Thank you, Honorable Chief Justice.
Yes, thank you very much. I'll go to another area and ask you what you understand by the term judicial independence.
Thank you, Honorable Chief Justice. Judicial independence is provided for under Article 160 of our Constitution, which requires that in exercise of judicial authority, the courts will be guided by the Constitution, and the laws shall be subject only to the Constitution and the law, and they shall not be subject to any control of any other person or any other authority. Therefore, judicial independence is crucial to ensure that justice is delivered that justice is delivered in a way that is acceptable to those who receive it.
So, for you to be independent and to demonstrate to the people you serve that you are independent, what perspectives or factors should you take into account?
Okay, for me to be independent, I have to ensure that I do not allow any external influence in my decisions, and that I'm only guided by the law in arriving at the decisions I arrive at, the law and the facts of the particular case.
Okay, so in the course of your work and your decision making, you say you have developed a wealth of jurisprudence. What philosophy guides you in the discharge of your duties, and when you are resolving problems, what really guides you?
Thank you, Honorable Chief Justice. I'm guided by the fact that I need to ensure that whatever decisions I come up with are consistent with the Constitution, the requirements of the Constitution, and I ensure that I uphold the values and principles in our Constitution, so that when I arrive at a decision, it's a decision that will be acceptable even to whoever comes across it. Like in most of the cases, we deliver judgments in open court, and you find the people who have come there also following and you find them reacting to whatever you say. So it should be a decision that even those people who are there will really say that, yes, justice has been served. So that means that it should be a decision that is, will be acceptable generally to the society, and which is according to the law.
And what philosophy do you call that one?
Okay, so in reaching that particular decision, I'm usually liberal. I'm liberal because I am able to, I'm open to the developing the law in whichever area that I'm dealing with. So I am not conservative, such that I'm not tied.
Okay,
Yeah.
thank you. The next set of questions will be asked by Commissioner Justice Ibrahim, Judge of the Supreme Court.
Good morning once again.
Good morning, Judge.
Yeah. My questions will revolve around the questions of leadership, and also the question of your understanding of the structure of the court system, and the issue of generally on leadership, transformative leadership. You have been in the judiciary for 18 years.
15 years.
15 years.
Yes.
Under council for how many years?
2 years. I
2
only
years,
practiced for
yes.
2 years. Yes.
Yes. What role? Because you didn't play. You didn't stay in the bar too long, but in terms of leadership, what role do you think you have played in your capacity as a magistrate from the time you joined until now? What contributions have you given in terms of leadership?
Oh, thank you, Honorable Judge. I've headed 2 stations, that is Bomet and currently Ngong Law Court, and I've been able to transform. I can say that I'm a transformative leader because I've been able to transform the station and also leave the station better than what I found. For instance, as I've said, I put at the forefront service delivery. So whichever station that I've headed, I've also brought that idea to my team members, and therefore we have been able to change our work methods. Like if there's a station I go to and I find the staff report late and service delivery to the Mwananchi begins late, I've been able to transform that such that if you come to Ngong Law Court even by 7:30, you'll find a vibrant court with people there being served. Yeah, so I've been able to transform that as well as also to change the culture, and also just to encourage the staff to understand their roles, why they are there, and that has also helped some of the staff even to be recognized by the stakeholders. Like last year, there's one of the staff who is in charge of a civil registry who was recognized by the Law Society because of the contribution he has done, and that came about by the motivation and the direction that I was able to give the staff on how they should do their work. Thank you.
Further, what are the, you have gone deeper and even answered some questions which I would have given answers to some questions which I would have asked. What is your, what do you understand by the vision and mission of and core values of the judiciary, and particularly that of the current Chief Justice, which he launched a year ago?
Okay.
And you know that the motto, the mission, what is it?
The mission
Yes.
of the Chief Justice?
Yes. Judiciary social transformation
Yes.
through access to justice.
Yes.
You know about that?
Yes, I know.
What does that entail?
Yeah, so the vision in the social transformation through access to justice is to have a judiciary that is independent, efficient, and accessible, and one that that is able to meet the aspirations of Kenyans, and one that is in the forefront to promote the rule of law.
Okay.
Yes.
What challenges did you see in the magistracy regarding what challenges did you face in respect of organization, the structure and organization of the magistracy, and how did you overcome any if you met them? Is there any comment to like about the structure? Are you happy with the structure? Is there a way that we can improve upon it?
Okay, I've not encountered any challenges with the structure. I think I've not noticed any problem with that. Yeah, only for, maybe I can say that there was a proposal in the JTF, Judiciary Transformation Framework, on incorporating counsel, like counsels for each court, to be able to advise the litigants who are not represented on processes. I think if that is implemented in every station, it will help, because at times you are dealing with a matter and there's a litigant who does not understand. So you're at a loss, how do you start advising? Yeah, you are not able to do so. The best thing, the only thing you can do is to refer them to the registry, yet the registry, they are just the court assistants who do not really understand the law. Yes.
Thank you. Last but not least, how did you, I'm sure you went through some induction and training in technology and application of technology, IT, in our work, particularly during the COVID period. What?
Sorry, Chief Judge, I did not undergo any training.
Okay.
Yes.
How did you then overcome any challenges, and how did you work it out?
In fact, it was a big challenge because we had no ICT officer at the station, so it was just my own initiative. You know, I just taught myself this, the virtual platforms. I was not so familiar with them, but I just started working on it on my own. In fact, I just learned how to create links just by learning on my own. But where I get stuck, I'd get an ICT officer from other stations. You could get even an ICT officer is within that area from another station, so they came in handy to support. So it was just learning. I just learned on my own, and we have sustained the virtual courts up to now. Even the stakeholders have already embraced.
Thank you.
Yes.
And back home or in society, what achievements, what leadership, or rather, have you been recognized as a leader in your community? And if so, give us an example.
I've not really been in leadership positions like in society, but what I do is I support a lot of activities, even in whatever the presentation I presented before the Commission on Community Service. That was just a little bit, because I did not want to really go into the very other deep issues, because maybe they touch on other people, and without their consent, I wouldn't want to bring it out. Yeah. Yes. Thank you. Thank you, Judge.
Thank you, Honorable CJ. Just a few questions.
Yes.
Now, in terms of making sure that cases are expedited, because this is one area that we are confronted with a lot of complaints generally. Your station is different. I must say that, you know, I can confirm about what you are saying about the stakeholders being happy. Now, what techniques would you apply, very briefly, if you became a judge, to ensure that cases are expedited, but not just expedited, but also in terms of the quality delivery of decisions, where this expediting, but also without compromising the quality? What are the techniques that you think you would apply to ensure that happens?
Thank you, Honorable Commissioner. Yes, the techniques that I would apply just for expeditious hearing of cases, I think it's very important. Time is usually crucial. So just as I stated initially, I ensure that I begin court on time, because if you start early, it will mean you'll be able to handle a lot of matters and finish the course list, and therefore close quite a number of matters. And now when it comes to preparing the judgments and rulings, you know, most of the time, most of the magistrates' courts have a lot of work. So you find that in a day you have a long course list, you can even sit the whole day. So the question is, what time are you writing the judgments? So I think it's important for the magistrates' courts to be supported by legal researchers so that they're able to help in the research work, so that the magistrate will be able to take faster to write the judgments, and it will be quality because there'll be research. Yes.
Yeah, but now,
Yes.
you know, as a follow-up on what you've just stated,
Yes.
you can imagine as magistrates you don't have those legal researchers. You have so many cases, and some of you are able to handle them in a satisfactory manner. But you become a judge, you have that legal researcher, work is less, and then now you start, you know, going back on the abilities and the manner in which you're performing. What is it that informed that? Because there has been those cases where someone like you, who probably was doing well as a magistrate, but you become a judge, and now, you know, laxity now creeps in. How do you prevent that?
Okay. I think also that comes also with self-discipline. Just be able to be disciplined and to do the right thing at the right time. Because now with the legal researchers, I think it should now make the judges' work much easier, and they should even be able to handle more within a short time. If you are able to handle as a magistrate and you are alone, I think it should also impact on whatever output. Therefore, I think it just boils down to being self-disciplined and committed to your work.
My final question is on accountability.
Yes.
As a judge, how do you ensure that you are accountable to the public in terms of confidence building? What is it that you would ensure that you do, or you think that should be done, in terms of making sure that the judiciary is also held to account by the public?
Thank you. For accountability, I believe that we should be able to be professional. If you're professional in your work, you also have the values, inculcated values. Serve the people with diligence and openly, and not putting yourself in situations which will make the public believe that you're not doing the right thing, and therefore the confidence will go down. So I think the manner in which the judicial officers or judges carry themselves is also very important in building confidence to the public. Yes. Thank you, Judge.
First one is, what is the difference between the balance of proof and the standard of proof? Those are daily things you do every day. I said burden of proof and the standard of proof.
The burden of proof is what you should consider when you're determining the case, at the final, when you're determining the case during judgment writing. So you'll consider whether burden of proof has been achieved before you decide whether you're deciding whatever decision that you make. The standard of proof, what I understand that to mean is that it could even be when you are considering evidence that has been presented. So you're asking yourself, does it meet the standard of proof to prove a particular thing? So the burden of proof, standard of proof can come in the course of the matter, but the burden of proofs helps you to decide in a judgment how you're going to rule the case.
Is there a situation where the burden of proof in a criminal case shifts to the accused person?
Yes.
One instance.
Yes, I can say where where he's charged with the offense of being in possession of something, then it's him who will the burden will prove of proof will shift to him to explain how he came by that item.
Okay. Under Section 35 of the Arbitration Act, there are 4, 5 situations when arbitral award can be set aside by a high court judge, by a court of appeal judge or the Supreme Court. Tell us 2 situations.
Okay. The first situation would be where the arbitrator went dealt with matters which were outside the reference, and the second situation would be where maybe he failed to consider matters, some evidence, and therefore the decision that was reached was not proper.
Okay. There's a case which you will always deal with, both as a magistrate, as a judge. Gela versus Kasman Brown. You've heard about it?
Yes.
What was the course of action about?
Sorry, Honorable Commissioner. Actually, I've looked for the facts of that case, but
Not
I've
the
not.
facts,
Yes.
the course of action.
The course of action. Okay, I have just dealt with it in terms of
And you deal with it every day more
requirements.
than 20 times, more than 10
Yes.
times.
Requirements for granting an injunction.
Not the requirement.
That is how far I've dealt with that authority.
Okay.
Yes, thank you.
That is how felt you need to look at it. Again, under sections 360 up to 364, God willing, if you are appointed as a judge of the High Court of the CPC, you will have certain powers under 360 up to 364. What is the difference between appeal, review, and revision? That's my last question.
Thank you, Honorable Commissioner. Appeal is where the appellant goes to the High Court on appeal on the final determination of the matter, and therefore the court in the High Court will be looking at the facts as well as the law in deciding whether they'll in deciding whether the decision of the lower court was okay or not. But on revision, they'll be looking at whether in arriving at that decision, the process that was followed was within the law, was correct, and also whether that decision was arrived at, it was properly arrived at. And in
Okay.
review,
Let me give you an opportunity now.
yes,
You look at it, and this is my last question.
yes,
Under Section 85A of the Elections Act, the jurisdiction of the High Court or the Court of Appeal kicks in when 2 conditions are satisfied. Tell us 1 condition. Because you will also be dealing with a lot of election petitions. Now, yes.
Thank you, Honorable Commissioner. I think I looked at it, but it has escaped my mind.
I wish you well. Thank you,
Thank you.
Honorable CJ.
Thank you, Chief Justice Chair, and welcome.
Thank you,
Um,
Judge.
You have submitted your sample writings, which are actually your very recent judgments, covering your broad areas of law which you deal with, and I can only say you write well, write simply, and you're consistent in the way you write.
Thank you, Judge.
I just want to ask you one or two questions arising out of your judgments on the issues of substantive law and procedure. When you become a High Court judge, inshallah, as my colleague says, criminal appeals, you will deal with a lot of robbery with violence criminal appeals. In fact, that is almost 80% of the criminal appeals you deal with. And the issue of identification is very critical. And I've seen even in one of your judgments, you have dealt with the issue of identification in difficult circumstances. There are decisions that say that the first report you make to the police station or to another person is very, very critical. That I was being robbed, I saw X, Y, Z, or I saw somebody described as so and so. The question I want to ask you is the failure to identify an alleged robber or a suspected robber in the first instance fatal to a conviction?
Thank you, Honorable Commissioner. No, it's not fatal, because the court has to consider all the circumstances, including the time of the offense, if it was at night, what lighting was there, plus all the other circumstances, including how that offense took place. Maybe even there was a fight and this person, you hit this person, maybe he had a mark. So the court has to look at all the facts which have been presented, so it's not cast in stone.
Okay.
Yes.
And what does the court say about that principle? In order to uphold the conviction, what must the court be satisfied in terms of identification?
Yeah, the court has to be satisfied that the identification was done and there was no possibility that there was of error, that there could be any error.
Okay, thank you very much.
Thank you, Judge.
The second last question, yes, wish to ask. Of course, as a judge, as a magistrate, you're expected to keep up with the developments of the law. You are aware of the Children's Act 2022.
Yes.
Just give us two new developments that it came up with, that particular act, just two of them.
Yes, the first one is it has increased the age of criminal liability for children from 8 to 12. And secondly, something which it's a bit difficult to know how to interpret, because it's saying that age will be computed from the time of conception. So you wonder, how will you know the time of conception? So that's food for thought.
So as a High Court judge, what principles or what interpretative tools would you use to talk about conception?
Okay, we are waiting for this.
Now you are the
Superior
High
Court to
Court
decide.
judge. You are the
Okay.
High Court judge. The first day you are
Yes.
there, and that issue comes. What interpretative tools would you use to say that Miss So and So now, this was the date of conception?
I think that may be I may have to get more information from the medical personnel on that one, because as a judge sitting there, you may not be able to decide.
Okay.
Yes.
And finally, there is a case which you did, the Barrio case between the Barrio case. One of the issues as an appellate judge, and I'm speaking from experience, is the time, normally by the time appeal comes, I even had one which had taken 3 years. In the subordinate court, it had taken 3 years to hear, and of course, there are problems with that length of time. But I note from your case, it was filed on 1st of December. 1st of December, isn't it?
Yes.
And then you delivered a judgment in March. That's a period of how many months? Almost just slightly above 3 months.
Yes.
Almost going to 4 months. Now, is that a concern for you with hindsight? Is that a concern for you? Or what is it you would have done better to make sure that it is expedited so that the parties are able to get the decision quickly and bury their deceased as soon as possible?
Okay, thank you, Judge. That decision, it was also affected by the Christmas period, because I was actually, I was not on leave. I was ready to hear the case in December, but it's the parties who requested. that we hear the case in January. So that's how we had the case in January. In fact, there was first an interlocutory application, yeah, which I had to deal with on whether we are preserving the body in the mortuary before we hear the case. So I had to deal with the interlocutory application first, and then I moved to the hearing. But it was the parties who requested because of the Christmas holiday. Yes.
So, for example, when you come to the High Court, and if again inshallah, you'll find that kind of scenario where you have a case which you should hear quickly, and parties file interlocutory applications. Tell us two strategies you'd use to dispose of interlocutory applications or avoid interlocutory application in order that you get to the substance of the issue, and that will be my last question.
Thank you, Judge. Actually, there are some cases where after looking at the application, I normally just engage the advocates and I tell them, yeah, can't we just compromise this way? So there are quite a number of cases where they agree, and then we just make those orders and then we move to the hearing. So I think I could also use that approach. So it depends on whether the parties are agreeable to some of those matters, so that you don't have to hear them.
Thank you, Chair.
Thank you, Chair. Your Honor, what is the difference between judicial overreach and judicial activism?
Thank you. I think judicial overreach is where the court is making a decision that may be going too far. I think it's going too far, as in the order that you have made, they're even difficult to implement, to enforce. But judicial activism is where it's one of the philosophies that some of the judges have adopted, and in my own view, I think it's their own way of developing the law using the judicial activism.
Okay, thank you. I want you to, there's one of the sample writing you have shared is that of a burial dispute. The case of Agnes Wanjiru Gashoka. I don't know whether you remember the facts.
Yes.
It's a case that relates to burial dispute between a spouse who is in a monogamous marriage that was not dissolved and a cohabitee. And in allowing the cohabitee to bury the deceased husband, this, if you allow me to read part of your decision, is that the relationship between the plaintiff and the deceased and their conduct toward each other was that of people who were on paper married but practically divorced. Could you maybe explain to us, because you are aware of the Marriage Act and how the process of dissolution of marriage is supposed to be done, and whether in you making this determination there was the aspect of judicial overreach?
Okay. Thank you, Honorable Commissioner. So in that case, the deceased and the plaintiff had separated over 20 years ago, and they were not even in touch. So until when the deceased was ill, the plaintiff only visited once prior to his demise. So practically, there was no relationship, but it was only on paper. Yeah, that is what I meant. And then I also referred to to Article 45 of the Constitution, and also relied on the decision by Justice Nyakundi, which had also dealt with similar issues, and he had referred to Article 45 of the Constitution about family, where people have the free will to associate.
So according to you, a marriage certificate is not a valid document.
No, it's a valid document, and I think that's why I recognize that both of them were married, because on paper, the plaintiff was married to the deceased, but though practically not. Practically, he was married to I think it's the first the first
The
defendant.
plaintiff.
Yeah, no.
Yes, the plaintiff.
With the plaintiff, they had the marriage certificate, but with the, I think it's the first defendant.
Yes, the cohabitation.
Yes,
Mhm.
that is now what he the deceased knew was he knew now that defendant was the wife, because practically they were living together. They lived together and they had 4 children for over 20 years.
So would
Yes.
cohabitation be considered a marriage when a party lacks capacity to enter into subsequent relationships? Because I think that was the issue in that case.
Thank you. Actually, it also clicked my mind, but Article 45 of the Constitution, I think, in developing that law and the rights of people, their free will to associate, because I don't think it will be fair to say that since you have separated for all these years, you cannot now associate with anyone else simply because you have not formalized the divorce. I think that will be against Article 45 of the Constitution.
Okay. My second question is again with regards to a matter that you handled while you were in Bomet, the unfortunate incident of gang rape. From the facts of the case, that's Bomet Criminal SO number 30 of 2016.
Yes.
The facts of the case were that the complainant, who unfortunately died before recording a statement, was gang raped by 3 persons who are listed in that particular judgment. The post-mortem report did not indicate that the deceased was sexually assaulted. The deceased did not have an opportunity to record her statement, and the witnesses, majorly of them were giving hearsay evidence. And reading through your judgment, in determining that there was rape or gang rape, just a moment, let me look at what you mentioned. In the present case, I have no doubt that the deceased was raped. I say so because she spent the night at the home of the second accused person, and all this information was hearsay. It was probably because of the action, that is rape, committed against her, that she took poison and later passed away. Where did you get this information that the possibility of her taking poison was as a result of rape?
Yeah, I got that from evidence of the witnesses. Yeah, there's those who saw the deceased with those accused people, and even those who saw her going to the house where she was gang raped. And also after that, she told some of the witnesses what had happened to her. And I remember one of the witnesses who she even told when she was so devastated, thereafter she took poison. Therefore, it was as a result of that gang rape that she took the poison. And yeah.
So that is according to you, not from the evidence presented?
From the
Because
evidence, having looked at the whole evidence and even the circumstances of that case, that would be the only logical conclusion to reach.
do you think you have the powers to come to that logical conclusion that she was raped because the reason why she took poison is because she was raped? There is no medical evidence to that effect, and the deceased died before recording a statement about the incident. Okay. Are you aware that the
Sorry,
Court of
let me
Appeal...
just say something also. Because I think she died several days after the incident. So even by the time she was, the body was being examined, there was nothing. Just like a normal person, if you're raped and it takes several days, most of the time the doctors are not able to get that evidence, and I was appointed in the judgment.
Okay, are you aware that the High Court overturned your decision and said that you relied on hearsay and the postmortem report did not indicate any injury?
Okay, the High Court decision, I think it was not brought to my attention.
Okay.
So, yeah, I'm not.
Okay, thank you.
Thank
Maybe
you.
you can have a look at it. Criminal Appeal number 18 of 2017.
Thank you.
Thank you. That is all.
Thank you, Madam Chair. Good morning once again.
Good morning, Commissioner.
I will focus on non-legal issues, and I'll be very brief. The first thing is you've been in the service for 15 years, I believe. Would you share with this commission one thing in those 15 years that you did or got involved that had an impact in judiciary? One thing that you can be proud of in those 15 years that you did that had an impact in your career?
Thank you, Commissioner. What I can say is my contribution to reduction of case backlog throughout the stations.
Which
where
station in
I have served.
particular? Be specific.
I have served in Bungoma, but during that time there was no performance evaluation, though the head of station, who is now Justice Nyakundi, had come up with we had our own monthly evaluation system, where every month you would present what you have done. So we started the evaluation much earlier, even before it was entrenched in the judiciary, and through those reports, yeah, I was able to reduce the case backlog, as
In
well
Bungoma?
as yes, in Bungoma, as well as in Kakamega. I can also say that I contributed to that, though at that time we did not have evaluation, but
Okay.
I could see just from the matters you're handling and the years, because if you find old matters and you're able to deal with them, by the time you're leaving the station, you're only left with the matters
Okay.
for that year and the previous year. So that shows, yes.
That's good, Madam Achieng. The other question is about efficiency, enhancing efficiency and effectiveness in service delivery. And that is the core in public service now. Would you share with this commission your thoughts or two strategies that you are going to apply in case you get this position to enhance efficiency and effectiveness in your court as a judge? Just two.
Thank you. To promote efficiency
And effectiveness.
and effectiveness
Yes.
as a judge,
As a judge.
yes, I will still adopt the methods that I'm already adopting now because they are working. That is to ensure that I begin my court in time. I'm able to handle as much
I want you to
as
upscale
possible.
that. I want you to upscale that.
And
Something much more substantive. You're talking about a strategy to enhance effectiveness and service delivery in your court.
yes, and also I'll also be able to ensure that I do, like during the pre-trial conference, I be able to do the pre-trial conference and be able to identify issues early and also see whatever can be ironed out, which does not have to go to hearing. That will also help to expeditiously deal with
Good.
the cases.
Next.
Yes, and also to ensure that litigants and also advocates adhere to the rules, just to be strict and enforce of the rules, so that when something is supposed to be done at a particular time, I ensure that it is done so that we are not delayed.
Could you address yourself to communication as a strategy?
Yes.
Communication as a strategy, as a judge.
Yes.
Yes. Can you address yourself to that? How would
Uh,
you enhance communication?
Yes. On communication, I ensure that if there is any information that is to be passed to the litigants or advocates, the same is communicated in good time. Yeah, so that yeah, it will also help enhance the efficiency of the court.
Okay.
Yes.
Stakeholders, very key. Would you share with this commission, as a judge or even as a magistrate, two key stakeholders as far as judiciary is concerned? Just name one or two key stakeholders.
We have the Law Society of Kenya, and we have the Office of the Director of Public Prosecutions.
Okay, Law Society of Kenya and DPP.
Yes.
Could you share with this commission two ways that you can enhance stakeholders? Your engagement with the Law Society, your engagement with the DPP.
With the Law Society, we have the bar bench meetings where we engage. And even in our station, we also have the WhatsApp. It's a quick way of communicating. So in case of anything arising at any time, they are able to raise it on the WhatsApp and we are able to address it. Though we also have the bar bench meetings where we
Bar
start-
bench,
yes.
what else?
Also on a day-to-day running of the business of the court, in case of anything, they communicate through the court administrators, so that if there's anything that we need to address, then we are able to do so.
Office of the Director of Public Prosecution.
For the Office of the Director of Public Prosecutions, apart from just having, if there's any issue that is arising, at times I'll call the prosecutor in charge of the station and just discuss the issue. But other broader issues we discuss in the Court Users Committee, where there are also members. Yes.
Or the resource management, scarcity of resources. I'm sure the resources will be made available to you by the judiciary. Would you share with us two legal frameworks that guide the use, management of public resources? Two legal frameworks.
Yeah, we have the Procurement Act, and we have also the
It's called the Procurement Act. Can you give us a full, you are the lawyer. What do you call it?
Public Procurement and Disposal Act,
Yes.
and we also have the Financial Management Act. I may have missed the correct name.
Two values in managing public resources, as per the Constitution. Two values that you guide any public officer in the utilization of public resources.
Public resources should be managed efficiently, and in a way that does not lead to waste.
That is efficiency. Something else. I want you to think hard. You are going to be the judge of the High Court, a very big position. It's also be at your disposal. I don't want you to be caught up in a situation that you are not managing the resource properly. Efficiency, what else? Have you heard about the Office of the Auditor General?
Yes, I have.
Two duties for that office?
They do external audit, and also I think I can only remember external audit.
What is your responsibility to that office as a judge or as a head of a station? As a head of station more than the judge, what is your responsibility to that office?
To ensure that whatever funds are allocated to the station are managed effectively according to the work plans and the procurement plans which have been prepared for the station.
Okay. Thank you. Thank you.
Given the amount of facts that they have to sift through. So explain to us some of the coping mechanisms that you use as a judge if you are successful to cope with stress?
Thank you, Honorable Commissioner. Yeah, even at our level currently, the work is very stressful, but I ensure that after the work, I engage in activities that will help me, just relieve the stress, like doing workouts, just to ensure that I'm fit and also to relieve the stress. Yes, and also just finding, giving myself enough time to rest, to rest before embarking on the next work activity.
Given your busy office, maybe you can advise us. Do you do the workout in the morning or after work or on weekends?
After work.
After work.
Yes.
You
after
get some
work.
time to do that.
Yes, just in the house. I don't have to go to the gym or anything.
Yeah.
So just in the house.
Okay.
Yes.
Would you say you are diligent worker? And if so, just explain what that means.
Yes, I can describe myself as a diligent worker because I'm self-driven. I do not wait for anybody to tell me what to do. I plan my work. I ensure that I go to the office every day by 7:30. I'm there, and I plan my work so that by 9 I'm ready to begin the court session. And also I ensure that I deliver the rulings and judgments without delay or any other, if the litigants want something to be done, even the certificates of urgency and all those other issues that the litigants will want to be addressed, I ensure that I use the minimum time possible to address them. And also the registry has been telling me, most of the staff keep telling me that we've never seen this. In other stations, you find certificates, you'll get orders the following day. But here we ensure that we work and issue those orders the same day.
My last question, Chief Justice, is that judges are supposed to be these people who don't show emotions, even though they are emotional beings.
Yes.
So how do you balance that? How do you balance between not wanting to show your emotions to the people before you, and yet some of those things that you are doing are very emotional? How do you deal with that balance?
I think I just have that in me, because actually there's one person who commented that, Madam, when you're seated there, nobody even knows what you're thinking. Yeah, so I think it just comes to me. It's natural. I'll just be there and listen, but you will not know what I'm thinking. I'll only express what I'm thinking in the judgment.
So do you make a put an effort to make sure that you are not showing emotion?
Okay, for me, I don't struggle. I think it just comes naturally.
Okay.
Yes.
Okay, thank you.
Okay.
Thank you, CJ, Chair. Pam, it's been a long morning. I'll be brief. I don't really have much to ask you.
Thank you.
Maybe just straight to the point. Why do you think we measure our performance in the judiciary?
Yes, we measure performance so as to ensure that we are able to rate ourselves and to know where we are in service delivery, so that if there's any challenge, then we are able to address, in order to ensure that we offer good services and that cases are expeditiously heard and determined.
Okay, thank you. Now, I've looked at your performance, the report we have from Depop. Your performance generally is very good. It shows you carry your weight. Your court productivity is very high, higher than the national average by over 100%. There are also signs, just like you have said that you work on backlog, there are signs that you have a concerted effort towards backlog, clearing of backlog. The report shows that out of the 4,280 cases pending in your station, only 644 are backlog, and 257 backlog over 3 years. I think that's quite good. However, your court clearance, case clearance rate is far below the national average. The national average is 83, while your case clearance rate is 75. Now, you said earlier that performance measurements enables us to rate ourselves, how we perform, and also where to help us identify challenges and how to address them. Now, I have given you a report on your station. What does it tell you? Your case clearance rate is quite high, quite low, yet your productivity is very high. What does it tell you?
Thank you. I noted that, but if I compare with where I have come from, that one is a big improvement, because when I went to the station, criminal matters were not moving at all. Yeah, so I had to engage the stakeholders in criminal area, the DPP as well as the police, and now that is an improvement, because clearance rate for civil was much higher than criminal, and I kept telling them I've never seen this in any station. Criminal matters move faster than civil, but that one was opposite. But now we have already turned that around, and therefore we are still working on it. And therefore, with time, I'm sure we'll be able to reach where we should be. Yes.
Okay, thank you. But with this report, have you identified any challenge with the report I've just given you?
Yes, it's still, we are still not there with the criminal matters, because I still experience challenges, police files not coming, witnesses not coming, and I've been trying to find out what is the cause, and then you find that where Ngong is a unique place, because you'll find that an offense happens, the person is resident there, and then after a short while, especially after COVID, quite a number of people relocated back to their home areas. So you find that getting witnesses or the accused people coming to court has been a bit of a challenge. And like what I saw in Bomet, where they are most of the people are residents there, so getting witnesses and accused people was not a problem, but we are still addressing it.
Okay. Another area of your performance is on the corruption prevalence index. This was as of 2019. I realize from the report that I have that by then you were in Bomet, and the report I'm reading you is from Ngong. The corruption prevalence in Ngong was very high, at 13.04% against the national average of 7.03%. So now that you are in Ngong, I'm sure you must have familiarized yourself with that, and what strategies have you put in place to cure this sorry state of affairs?
Yes, those are the first things I normally check when I move to a station. So I saw it, and I asked myself, what can we do? So I keep emphasizing to the staff during the staff meetings about issues of corruption. I sensitize them, as well as during the CUC meetings, just to sensitize stakeholders that we will not condone that. And at the moment, there was a memo by the chief registrar requiring us to establish the corruption prevention committees in the month of April, which we have already embraced, and we have already formed the committee. We even had the first meeting with the staff. So we have already put in place activities which we will undertake to ensure that we sensitize the staff as well as the stakeholders, so that probably by the next time they do the report, that will have changed the picture.
Okay, we'll hold you to that promise.
Yes.
I'll not ask you anything about case management. I think in your answers to earlier questions, you've already addressed your strategy on case management. Now, community service. I have seen what you do in your CV for community service, and I just have one question to ask you. Why do you think it is important to participate or engage in community service?
It's important because it's a way of giving back to society, and also it's a way of ensuring that we can also use those forums to sensitize the members of the society on certain areas which are critical to them, and therefore enhance access to justice for them.
Okay, thank you. Lastly, I have looked at your vetting documents. Everything is in order. The report we receive is that you are an honest and respectful person. You give a listening ear to all. You have a good grasp of the law, good control of your court, good time management, and good temperament. You're also well balanced in your judgments and rulings. Thank you for serving Kenyans so well in such an admirable manner, and I wish you well. Thank you, CJ.
Thank you.
Thank you. Which is your county
Busia County,
and your ethnicity?
Luya.
You know why we ask those questions?
Yes, Honorable Chief Justice.
Yeah, why?
Article 232 of the Constitution requires that there be representation from all communities in the countries in the public sector. So,
Okay.
yes.
Yes, thank you very much for the engagement. That brings us to the end of the interview, but we always ask our candidates whether they have any question to ask the Commission.
I do not have a question, Honorable Chief Justice, but just to thank the Commission for this opportunity. I think it has been a good engagement, and I just want to thank you for giving me this time.
Thank you,
Yes.
and wish you all the best.
Thank you.
Yes.